Hello again. My heart always sinks when I see Magna Carta being invoked in this country, as though it has some kind of relevance in this modern world of ours. It does not. It was trending on Twitter yesterday, and people were claiming that Magna Carta guaranteed free speech in this country and all manner of other things. Keir Starmer was said to be riding roughshod over our ancient liberties and, in effect, disregarding or even destroying the various protections promised to us by Magna Carta. Britain wasn't founded or created at any particular moment, nor was there any event which marked definitely its becoming a nation, such as the signing of a Declaration of Independence. Instead, in England, we have the Magna Carta. Before Magna Carta, there are a few memorable dates, such as 55 BC and 1066 AD, along with a handful of notable kings like Alfred the Great, William the Conqueror, and Richard the Lionheart. These rulers all seemed to do pretty much as they pleased. From 1215 onwards, though, following King John placing his seal on the Great Charter which the barons presented to him, we know that we've been living in a nation where the rule of law is paramount. Even the monarch is bound by the law to respect the rights of his or her subjects. This, at least, is the popular view, but it bears no relation at all to reality. Anybody who has not actually read Magna Carta, and that includes the overwhelming majority of people in this country, might have the vague idea that the Magna Carta is something along the lines of the United Nations Universal Declaration of Human Rights. Nothing could be further from the truth, and the plain fact is that 99% of the famous Charter has no conceivable relevance for anybody who's not actually living in the Middle Ages. One or two examples might serve to illustrate this point. Let's look at Clause 57. In cases where a Welshman was deprived or dispossessed of anything without the lawful judgment of his equals by our father King Henry or our brother King Richard, and it remains in our hands or is held by others under our warranty, we shall have respite for the period commonly allowed to Crusaders, unless a lawsuit had been begun or an inquiry had been made at our order before we took the cross as a Crusader. But on our return from the crusade, or if we abandon it, we will at once do full justice according to the law of Wales and the said regions. Well, unless you are a Welshman living at the time of the Crusades, it has to be said that this clause is not likely to have any bearing on your day-to-day life. Other clauses are equally meaningless to anybody not at war with the King of England during the 13th century. Clause 59 begins, with regard to the return of the sisters and hostages of King Alexander of Scotland. Clause 33 calls for the removal of fish weirs from the Thames and the Medway. So it goes on for 63 clauses, with nothing relating to anything other than the concerns of rich landowners in medieval England. This is not surprising, for it was the barons who drew up Magna Carta, and it was concerned with their interests rather than those of ordinary people. The original Magna Carta was issued in June 1215 and revised 5 times before the end of the 13th century. By that time it had been reduced to just 37 clauses. In that truncated form it remained as the law of the land until 1829, when George IV agreed to repeal Clause 26. Another 15 clauses were removed under the provisions of the Statute Law Revision Act of 1863 and also the Statute Law Ireland Revision Act of 1872. By the end of Victoria's reign in 1901, another 6 clauses had been removed. The last revision of the Magna Carta took place in 1969, when 6 more clauses were lopped off, leaving just 3 remaining clauses. All this might well come as a bit of a shock to those who have the idea that this venerable document is somehow sacrosanct and still of enormous importance to the true-born citizen of England. The 3 clauses which remain on the statute book are as follows. Clause 1. First, we have granted to God, and by this our present charter have confirmed for us and our heirs forever, that the Church of England shall be free and shall have all her whole rights and liberties inviolable. We have granted also and given to all the freemen of our realm, for us and our heirs forever, these liberties underwritten, to have and to hold them and their heirs of us and our heirs forever. Clause 13. The City of London shall have all the old liberties and customs. Furthermore, we will grant that all other cities, boroughs, towns, and the barons of the 5 ports, and all other ports, shall have all their liberties and free customs. Clause 39. No free man shall be taken or imprisoned, or be dispossessed of his freehold or liberties, or free customs, or be outlawed or exiled, or any otherwise destroyed. Nor will we not pass upon him, nor condemn him, except by lawful judgment of his peers, or by the law of the land. We will sell to no man. We will not deny or defer to any man either justice or right. That's it. The whole of Magna Carta, which is in British law. Some people have the idea that Habeus Corpus has something to do with Magna Carta, but it does not. This idea was devised half a century before Magna Carta in 1166, the very year that King John was born. In the aftermath of a bitter civil war, King Henry II set about reforming the law through declarations such as the Assize of Clarendon in 1166 and the Assize of Northampton 10 years later. Before these, each baron had administered the law as he saw fit, and some behaved as though they were actually kings of this or that part of England. The 2 assizes set out a new set of rules which wrested power from the barons and placed it in the hands of the king's judges, who travelled around the country dispensing justice. This was a very unpopular move with the barons, reducing their authority as it did. Habeus Corpus originated with the Assize of Clarendon rather than the Magna Carta, but even then it was a concept rather than a law. It was to be another 500 years, not until 1679, before Habeus Corpus was actually incorporated into the law of England. Those who rely upon Magna Carta or think it has any relevance to us today are mistaken. It is very unlikely that Starmer is planning to abolish any of the 3 remaining clauses of Magna Carta, but even if he did, it wouldn't really affect us. As I say, Habeus Corpus has never had anything to do with Magna Carta, and neither has freedom of speech.